We do all the hard work and they
We,
jump on board.
well, then they jump on board and undermine the case as well, don't they?
I've got loads of cases where I've got the XY60 and I've never had one refused on me yet.
No, well you see the point is this, is that we can chase it up all the way. And they cannot, they have no excuse. We have this case, 2 cases in Liverpool where it took me over a year to get the judgment.
Yes.
But once we kick that off, the embarrassment it caused the judicial process, because it is embarrassing, because they've got to give their reasons.
Is it the case I'm thinking of?
Well, maybe, but there is an interesting question as to whether you could appeal. David Howarth MP suggested one solution was to appeal an order on the basis of no reasons being given.
Absolutely.
All right, so if you could put the appeal in saying you haven't been given the judgment, and you should be given quashing order because of that, that'll elicit a judgment. One of the other problems is that what you often get is the bundle before the day before the hearing as well.
Or on the day.
Or on the day, yeah. Well, you're going. Some people are going to go now. So do you want to take? Should we switch that off to conversations? Because you need to get a drink. Well, there's some bottles of water around. All right. Sorry. No cups. There's 1 or 2. There's some cups down there. You can scrounge some of those. What I suggest we do is about 15 minutes more of, if anyone have got quick fire questions and trying to do answers, right? And then after that, we go on to just an informal conversation as we end the meeting, so, but we don't chuck everyone out straight away. Because we're supposed to finish using the room at 9:30. Now, I'm in no great rush. We could perhaps go for a few people to the bar. I can't take too many people to the bar because there are limits on how many people I'm supposed to wander around the building with. But and I may have to vote again as well. It's the adjournment now, so we won't have to vote again, that's all right. So, questions? Where's the water? There's some water there. Julia's now, do you want to talk about your tape recordings? Or not?
I don't mind, yeah, no, I don't mind at all.
Julia's got an interesting tape recording on the net of her arrest around about a year and a half ago, which people may wish to know, where she hadn't committed any criminal offence yet was arrested. And that's an interesting case to chase up, isn't it?
We should use common law on that.
We will be. Julie knows what she's doing. Don't you? You're very good.
Do you know about common law?
Sorry?
Do you know about common law? Magna Carta.
Sorry?
Let's use Magna Carta in that one.
I don't think you can use the Magna Carta these days. Most of it's been appealed.
61.
Article 61?
Yeah.
Alright. I think we'll move on from that, shall we?
Yeah.
No one's showing any views. Questions? Speak, well, I know you email me all the time anyway. Speak now or well, you know, so we can always end the meeting a bit earlier, or we can talk about something completely different.
Couldn't we do some research on particular issues?
Well, we are doing research on issues, but the challenge is that we have to get better at getting the key information together, the orders, judgments, that sort of thing. Because you can have boxes and boxes of paperwork, but it's actually only really the judgments and the orders that you need to understand the case.
When I'm talking about research, I mean with a view to publications.
Well, I think there are different aspects to research. Research as to what's happening with disrupted adoptions is something the government should be doing. We should be putting pressure on them to do that. The medical research in terms of things like SBS, that's a job for medics. Now, I'm working with medics. We're in touch with a number of medics in that area. You know, we bring all that stuff together, but the statistical stuff, analysing what the SSDA 903 returns say, is actually something I've done because my background's in that sort of area. But we've got to be careful not to set out to have roles that it's not best for us to do. And it's definitely not best for us to do medical research. It's best to get medics to do medical research. To be fair to the Royal College of Paediatricians and Child Health, they have recently recognised that they should be producing evidence-based expert evidence rather than non-evidence, and they're actually doing more research. And although you can't do this, as the judges say rightly, you can't shake baby to see what happens. You can at least. Yeah, I know, but that's the point. The point about shaken baby syndrome is nobody has actually ever produced rigorous research apart from the Scheinberg research, which wasn't really research but clinical observation observations recently, which proved the opposite of what's generally accepted. I tabled an EDM about that earlier today. But you know, we are trying to put together information on experts, but it depends, to a very great extent, on getting into cases properly. Because if we do what some of us do, which is deal with the case, get all the details, get all the expert reports, and take the case through the courts up to the European Court, we know exactly what's going on.
So if we have a complete case, we could do a case history.
You can do a case history, and then we can summarise those centrally and research those and look for patterns. And we're looking for patterns like problems with Munchausen syndrome by proxy in the northeast, for instance. There's a big problem there. Now, a lot of that came from Fran Lyons. Still, you know, Fran Lyons, although she's living in Sweden with her baby, because obviously the easiest way to avoid the miscarriage of justice is to immigrate before the baby's born. And she's living in Sweden, but she's still doing support work from Sweden via email. And she's doing some work on Munchausen syndrome by proxy. All right, so you know we've got people in Ireland and people in Sweden, and obviously Ireland's the biggest group.
And Denmark.
Denmark, I haven't got Denmark. I need to know who's in Denmark.
All
Right. Denmark are very good on their child protection services.
that's why they're on there.
Yeah, no, it's so when you deal with the practitioners in Ireland and in Sweden, because I deal with them directly, and they are so much better. Sorry about this, but you know the bad practice here. There's too much of it, and in Ireland, generally it's good practice. There are bad practices in Ireland as well, but they are so much better, and Sweden is so much better as well. But it's a different culture, you see. In Denmark, with the DCSF select committee went recently to look at Denmark and the systems they use in Denmark. Much better.
Yeah, isn't it? So
think it's everywhere else.
ironic that England and Wales is distinctly out of step.
Yeah, it's out of step because of it's the judicial process. It's where, because it's all monitored by the Court of Wales, England and Wales. In Scotland, they have a unified bench. So in other words, you don't have family judges, you have judges. All right? So they don't develop the bad habits the judges have here. And also, although there are some problems, also Scotland has the children's panel, a sort of jury system. It's interesting, in Japan, they recently brought in a jury system for criminal offences because they found that everyone was guilty all the time. And it's the same in the family courts. The absence of a jury means that the establishment's all there, all good, let that one go through. Yeah. Sarah?
Are we ever going to be able to change the law?
Yes, the law is gradually getting changed, but part of it is getting recognition that the system's broken. Because if the government think it's all working well, they're not going to change things. And so one of the things we're doing is raising these things with the government all the time.
Is there any possibly what you just mentioned, a jury for a family?
Well, you could do that as well, but what we're trying to do in Birmingham, what I'm trying to do in Birmingham with Birmingham Local Authority is change the case conference. So the case conference has a more important role and is much more balanced, because if you did that, you see, all of these things shouldn't really happen in the Court of Law, because the Court of Law is the wrong place to deal with family law. Because it's the way it's presented and all the legalisations, and then the fact there's a court order for this that means you can't change that and the other, it's just not good. So what I'm trying to do with Birmingham Local Authority is to strengthen the case conference, make it more into a family group conference, and drive the cases through there rather than through the family courts, which is dreadful. It's just not good for the kids.
I think that's an excellent idea because case management or case conference.
Yeah, case conference, it becomes
essentially,
that's a much better system.
Steps where you can find
Yeah.
flaws in the previous.
Exactly, but the point is that if you run a proper system for case conferences, then don't have to shove everything into the family court.
I was speaking to somebody from Kent County Council, and they had a family planning meeting before it ever got to court, where even the extended family was.
No, that's the family group conference. Now, that's a very positive thing. Yeah.
Now, I actually thought that was
No,
quite
much
correct.
better.